exact sound my back made when it hit the stone walkway. Not a dramatic crack, just a dull, flat impact that knocked the air out of me and left me staring up at the underside of my sister's front porch roof. It was Saturday, May 17th, just after 4 in the afternoon. The grill was still on. Paper plates were stacked on the patio table. My sister Lauren was standing 2 steps above me, telling everyone I had slipped. I hadn't slipped. A neighbor was already dialing 911 while Lauren said it was a joke, that I had lost my balance, that I was always tense about nothing. I couldn't sit up without pain shooting through my lower back. I couldn't correct her. And before the ambulance even turned onto her street, she had her phone in her hand recording a short clip about how I had overreacted. That was the version that went online first. Lauren lives in a townhouse complex in North Raleigh, the kind with narrow driveways and identical beige siding. She bought it 3 years ago after her catering business started doing well. I rent an apartment 15 minutes away and work full-time as a data analyst for a regional insurance company. I spend most of my days looking at claim patterns and timelines. I notice details for a living. That afternoon was supposed to be simple, a small cookout, a few cousins, nothing formal. We had been circling the same tension for months about our mother's things after she passed last year. Nothing explosive, just small disagreements about what had been promised and what had not. The argument itself was brief. We were standing at the top of her front steps near the railing that overlooks the short walkway to the driveway. I had said I was leaving. She stepped in front of me. I remember the pressure of her hands on my shoulders. Not playful, not light. Then the backward motion. The steps were only 3 concrete slabs, but I didn't land on them. I fell past them off the last edge onto the stone pavers below. My lower back hit first. My head didn't strike anything, but I felt the shock move through my spine. For a few seconds, I couldn't breathe properly. The world narrowed to the taste of dust and the smell of propane from the grill. I heard someone ask if I was okay. Lauren said I was fine. She laughed. She said I was being dramatic. When I tried to roll to my side, the pain stopped me. It wasn't sharp like a cut. It was deep and structural, like something inside had shifted out of place. One of the neighbors from across the shared driveway came closer. He asked if I wanted an ambulance. I said yes. Lauren said that wasn't necessary. He made the call anyway. I watched Lauren's face change when she realized I wasn't getting up. The paramedics arrived within minutes. I could hear the siren before I saw them. They asked me what happened. I said my sister pushed me. I remember saying it clearly. One of them repeated it back as he wrote. Lauren stood a few feet away and said we had been joking around. She said I lost my footing. She used the word slipped at least twice. They helped me onto a stretcher. The movement made my back spasm so hard I gripped the side rails. As they wheeled me toward the ambulance, I saw Lauren step aside, holding her phone up at chest level. Later, I would see the clip she recorded. In it, she is calm. The camera is angled to show the steps, but not the space where I fell. She says I tripped and insisted on calling 911 even though I was totally fine. She says I have always been sensitive. By the time the ambulance doors closed, the video was already posted. At that moment, I didn't know how widely it would spread. I only knew that I was lying flat on a narrow stretcher, unable to sit up while my sister was telling a story that erased what had just happened. I work with timelines every day. Claims rise and fall on minutes, on documented sequences, on who called first and what was said. That afternoon, there were already 2 versions of the same event. Only one of them had me on the ground. By the time we reached WakeMed, it was early evening. The sky was dimming through the ambulance windows, and the paramedic had already radioed ahead that I was coming in with a suspected lumbar injury from a fall. They transferred me from the stretcher to a hospital bed with a rigid board beneath me to limit movement. A nurse secured a blood pressure cuff around my arm and attached monitoring leads to my chest. Every shift in position felt calculated, deliberate. I could move my legs, but bending at the waist sent a deep ache through my lower spine. The emergency physician on duty examined my back and ordered imaging immediately. A CT scan came first to rule out obvious fracture displacement. Then an MRI was scheduled because the pain pattern suggested more than a simple bruise. While I waited, a nurse asked me to describe exactly what had happened. I stated that my sister had pushed me from the steps. She typed steadily into the electronic chart. I watched the cursor blink beside the words she entered. Patient reports being pushed by sibling. That sentence became part of my medical record. Lauren arrived at the hospital about 30 minutes later. She was composed. She told the triage nurse I had slipped and overreacted. The nurse didn't argue. She simply noted that I had already given my account. The MRI suite was colder than the emergency bay. They positioned me flat, secured padding at my sides, and slid the table into the machine. The technician explained the sequence timing and reminded me not to move. The machine thudded rhythmically for nearly half an hour. When the imaging was complete, I was taken back to a curtained room to wait for results. I checked my phone for the first time since the fall. Messages had started coming in from relatives who had seen Lauren's post. A cousin asked why I had insisted on an ambulance if I was fine. An aunt suggested I rest and avoid family drama. The physician returned with the results. The CT scan showed no catastrophic displacement. The MRI, however, confirmed a mild compression fracture at L2. It was stable but real. I would need a back brace and several weeks of restricted activity. There was another note. The radiology report identified a healed compression deformity at a mid-thoracic vertebra. Older, no acute inflammation. The doctor asked if I had ever been treated for a previous spinal fracture. I said no. I had never had imaging done for any prior back injury. He documented that as well. Before discharge, I was fitted with a rigid lumbar brace and given instructions to avoid lifting, twisting, or prolonged sitting. A follow-up with an orthopedic specialist was scheduled for the following week. I was placed on work restrictions effective immediately. The discharge paperwork listed the diagnosis, clearly acute L2 compression fracture. It also included the mechanism of injury as I had described it. When I left the hospital, the sun had fully set. My sister's version of events was still circulating online. But now there was a time-stamped emergency intake imaging results and a formal diagnosis attached to the afternoon. The fall was no longer just a story. It had a record number. I spent Sunday mostly flat on my couch, the brace tight around my lower back, discharge papers spread across the coffee table. The pain medication dulled the sharpest edge of it, but it didn't soften what was happening online. By Monday morning, the clip Lauren had posted had been shared far beyond our immediate family. A few of her catering clients had commented publicly, calling me dramatic. Someone wrote that ambulances cost taxpayers money and shouldn't be used for sibling spats. I opened my laptop because that is how I process confusion. I work with sequences. If something doesn't make sense, I line it up against the clock. The discharge summary from WakeMed listed my arrival time at the emergency department 4:41 p.m. The 911 run sheet number was printed near the top. I logged on to the City of Raleigh's public records portal and submitted a request for the call log tied to that incident number. It was a standard form: date, address, approximate time. By late afternoon, I received an automated confirmation that the request had been received. The next day, a PDF arrived in my inbox. The 911 call had been placed at 4:12 p.m. I went back to Lauren's clip. The timestamp on the social media post read 4:26 p.m. In the video, she said I had insisted on calling 911 even though I was fine, and the situation had already calmed down. At 4:12 p.m., according to the city's log, a neighbor reported that a woman had fallen and might have a back injury. At 4:18 p.m., MES was dispatched. At 4:24 p.m., they were on scene. There was no gap where things had settled. I saved the 911 log to my desktop and printed a copy. The sequence was simple: call, dispatch, arrival, transport. That evening, my supervisor asked for documentation supporting my medical leave. I forwarded the ER discharge summary and imaging report. Within an hour, HR emailed me a formal notice confirming I would be placed on short-term medical leave pending orthopedic follow-up. The leave was approved, but unpaid for the first week. I calculated what that meant against my rent and utilities. It was manageable, but not comfortable. Later that night, I received a message from one of Lauren's longtime clients. She said she had seen the video and hoped I would take responsibility for causing unnecessary attention around Lauren's business. I looked again at the timestamps. The ambulance had been called before Lauren recorded her calm explanation. The official record contradicted the narrative she had published. It was not proof of intent. It did not show the shove. But it established something measurable. Her public version of events did not match the city's clock. For the first time since the fall, I felt the shape of the conflict shift slightly. Not in my favor, not yet. But the timeline was no longer a matter of opinion. It was documented. The neighbor across the shared driveway knocked on my apartment door on Wednesday evening. I had met him only a few times before, mostly brief exchanges about trash pickup days and package deliveries. His name was Daniel. He stood just inside the doorway holding his phone and asked how my back was doing. Then he said he thought I should see something. Daniel's townhouse faces the same narrow strip of concrete where I fell. His front door has a Ring doorbell camera angled slightly toward the shared driveway. He told me he had checked the footage from Saturday because he heard the commotion and the sirens. He didn't assume anything. He simply said the camera had captured more than he expected. We sat at my kitchen table while he opened the Ring app. The video thumbnail showed the top of Lauren's steps and part of the walkway. The timestamp in the corner read May 17th, 4:11 p.m. He pressed play. There was no audio, just the muted motion of people shifting on the porch. I could see myself turn toward the steps. Lauren stepped forward. Her hands came up, both of them contacting my shoulders. The forward movement was clear. My body shifted backward immediately after. The clip showed me disappear out of frame. Then a few seconds later, Daniel himself crossing the driveway toward the sound. There was no visible slip. No loss of balance before contact. He paused the video and looked at me carefully as if checking whether I wanted to continue. I asked him to replay it once more. The sequence did not change. Daniel explained that the footage was stored under his account and that he could download a copy if I needed it. He said he hadn't shared it with anyone else. I asked him to send it to me directly. He used the app to export the clip and emailed it from his personal account while I watched. The file included the original timestamp watermark from the Ring system. Within minutes, the video was saved to my laptop. I did not contact Lauren. I did not post anything. I did not forward it to relatives. Instead, I opened the folder where I had saved the 911 log and placed the Ring file next to it. The call to 911 had been logged at 4:12 p.m. The Ring footage showed the shove at 4:11 p.m. The sequence aligned. That alignment changed the shape of the risk. Up to that point, the conflict had been about interpretation. Whether I had slipped, whether I had exaggerated, whether I had misread the moment. Now there was independent footage owned by a third party recorded automatically before any of us thought about narratives. Later that night, I received an email from Lauren's business account. It wasn't addressed to me directly. She had forwarded a message thread in which a client expressed concern about family instability affecting scheduled events. Lauren's reply included a brief line stating that I had fallen accidentally and that online speculation was unfounded. The tone was controlled, professional. The Ring footage contradicted it. I could see the next layer forming even before I decided what to do with it. The story Lauren had posted depended on the assumption that no one else had seen the steps from another angle. That assumption was no longer true. I closed my laptop and set my phone face down on the counter. I still hadn't taken any formal action. The police had not been contacted again. No attorney had been retained. But the gap between her version and the documented sequence was no longer theoretical. It was measurable. I waited until Thursday morning to make the call. By then, the orthopedic referral had been scheduled for the following week, and the swelling in my lower back had settled into a steady, controlled ache. I had the Ring file saved in 2 places and a printed copy of the 911 log clipped to my discharge summary. I called the non-emergency number for the Raleigh Police Department. I referenced the incident number listed on the 911 run sheet and told the dispatcher I needed to add information to an existing call involving a fall with injury. An officer returned my call within the hour. He asked whether I was able to come to the district station or preferred a home visit. Given the brace and the stairs outside my apartment, I chose the home visit. He arrived mid-afternoon in a marked patrol vehicle alone. I showed him the printed 911 log first, then explained that new video evidence had surfaced from a neighboring property. I forwarded the ring clip to the department's evidence submission email while he sat at my dining table and confirmed receipt. He watched the footage on his department-issued tablet. He replayed the moment of contact twice, zooming slightly on the frame where Lauren's hands met my shoulders. He did not comment on intent. He did not speculate. He asked a series of structured questions instead. Had there been prior physical altercations between us? Had I sought medical care that day? Did I have documentation of the diagnosis? I provided the ER summary, noting the lumbar compression fracture and the physician's recommendation for restricted movement. He photographed the documents with a department camera and logged them as supplemental material to the original incident. Before he left, he explained the next step in neutral terms. Based on the video and medical documentation, the case would be reviewed by a supervisor and potentially referred to the magistrate for consideration of a misdemeanor assault charge. If approved, a warrant could be issued. That process could take several days. Nothing would happen immediately. After he drove away, I sat at the table where he had been and looked at the empty chair. The decision to make that call had closed off something. Up to that point, I had the option of keeping the footage in a folder and letting the story remain a family dispute. Once the video entered an evidence system with a case number attached, it was no longer private. That evening, Lauren sent me a text asking whether I had spoken to anyone about the incident. The message was short and carefully phrased. She said her insurance agent had mentioned a potential inquiry. I did not respond. The following afternoon, I received a voicemail from a representative of Lauren's homeowner's insurance carrier, requesting confirmation of the injury details and asking whether I intended to file a claim. The representative referenced the address where the fall occurred and confirmed that the property was insured under Lauren's name. I returned the call and provided only factual information: date, location, nature of injury, current treatment plan. I did not discuss the video. Within 24 hours, a claim number was issued. By the end of the week, I received written confirmation from the police department that the case had been forwarded for review by a magistrate. The letter stated that if probable cause was found, a criminal summons or warrant would be issued and served according to procedure. For the first time since the fall, the conflict had a formal channel. It was no longer limited to social media family messaging threads or private interpretations of a moment on a porch. The shove was now attached to an incident report, a video file in an evidence database, and a potential criminal classification. I had not confronted Lauren directly. I had not posted the footage. I had not asked anyone to take my side. I had made a report. That action could not be undone. The following Tuesday, 6 days after I filed the supplemental report, I received a call from a detective with the Raleigh Police Department. He identified himself as the officer assigned to review the case before it was presented to a magistrate. He asked whether I could answer a few clarifying questions by phone and confirm that the video submitted by Daniel was the same clip I had referenced in my statement. I confirmed that it was. He verified the file name, the timestamp watermark, and the email address from which it had been sent. He told me the department had contacted Daniel directly to confirm ownership of the camera and to obtain a formal consent form for release of the footage. Daniel had signed it that morning. The detective then asked whether I had received any communication from Lauren since the incident. I told him about the text message asking whether I had spoken to anyone and the voicemail from her insurance carrier. I forwarded screenshots of the message thread while we were still on the call. He did not interpret them as threats. He described them as potential attempts to assess exposure. He noted them in the case file. By Thursday afternoon, I received written notification that the file had been reviewed and that the evidence would be presented to a Wake County magistrate for determination of probable cause on a charge of simple assault resulting in injury, a Class A1 misdemeanor under North Carolina law. The language was precise. It did not assume guilt. It described the alleged act and the supporting documentation. That same day, my short-term disability claim was formally approved through my employer's benefits administrator. The payments would replace a portion of my income beginning the second week of leave. It did not cover everything, but it stabilized the immediate pressure. On Friday morning, Lauren called me for the first time since the fall. I let it go to voicemail. In the message, she said she had been contacted by an officer and had been told that a complaint had been submitted. She said the situation was getting out of control and that involving the police would only make things worse. She asked me to reconsider and to think about our parents. I did not respond. Instead, I scheduled a consultation with a civil attorney whose name had been recommended by a colleague. The appointment was set for the following Monday. I emailed him copies of the ER summary, the 911 log, and confirmation of the insurance claim number in advance. That weekend, Lauren posted again on social media. This time, the message was more restrained. She wrote that family matters are being reviewed and that she would not comment further. The original clip remained online. By Sunday evening, I received an automated notice from the county court system indicating that a criminal summons had been issued. The charge listed was simple assault resulting in injury. The document stated that Lauren would be served and required to appear in district court on a specified date 3 weeks later. There was no arrest, no dramatic interruption. The process followed its own timeline. I sat at my desk and read the summons twice. The shift was not emotional, it was procedural. Lauren's version of events was now formally classified as an allegation under review in a criminal matter. My injury was attached to a statute, not a family argument. I was not in control of the outcome. The case would move through court at its own pace. But the question of what had happened on that porch was no longer confined to private interpretation or online commentary. It had entered a docket. That fact did not solve anything, but it changed the scale. The consultation with the civil attorney took place on Monday morning, 10 days after the fall. His office was in a low brick building near downtown Raleigh, the kind that houses accountants and small firms that rely on repeat clients rather than billboards. His name was Thomas Avery. He reviewed the documents I had emailed in advance before I sat down. He focused first on the medical records, then on the ring footage, then on the police summons notice. He explained that while the criminal charge would proceed on its own timeline through district court, I had a separate right to pursue compensation for medical expenses, lost income, and ongoing treatment through a civil claim. Because the incident occurred on property insured under Lauren's homeowner's policy, the insurer would typically appoint defense counsel if a claim escalated to litigation. He recommended starting with a formal demand letter. By Wednesday afternoon, he had drafted it. The letter outlined the date and location of the incident, referenced the medical diagnosis of a lumbar compression fracture, attached copies of the ER summary, an initial physical therapy estimate, and specified the amount requested to cover medical costs, projected therapy sessions, and documented lost wages to date. The letter was sent by certified mail to Lauren and electronically to her insurance carrier. 2 days later, the insurer acknowledged receipt and assigned an adjuster to the claim. The adjuster contacted Thomas directly, not me, and requested authorization to obtain my medical billing records for review. Thomas advised me to sign a limited release specific to treatment related to the fall, not a blanket authorization. I signed the limited form. On Friday evening, my parents called. They had received notice of the criminal summons through Lauren. They said the civil letter felt excessive. They said families handle things privately. I listened without interrupting. I did not argue about intent. I stated that the medical bills were real and that the fracture had not healed overnight. The following week, Lauren's attorney entered an appearance in the criminal case and sent a separate letter to Thomas disputing liability. The letter asserted that the incident was an accident and that my injuries could have been exacerbated by pre-existing conditions. It requested full access to my prior medical history. Thomas declined the request for a broad release and reiterated that any evaluation would be limited to records relevant to the date of loss. At the same time, Lauren's social media account went quiet. The original clip remained online, but comments had been disabled. The adjuster scheduled a recorded statement with Thomas present. I answered factual questions about the sequence of events, my treatment plan, and the limitations imposed by my physician. I avoided speculation. The recording lasted under an hour. Afterward, Thomas told me the insurer would wait to see how the criminal matter developed before making any serious settlement offer. The tracks were now running in parallel. In district court, a misdemeanor assault charge was pending with a scheduled first appearance date. In the civil lane, an insurance claim had been formally opened, documentation exchanged, and liability contested. None of it had resolved the fracture in my spine. I still attended physical therapy twice a week. I still moved carefully downstairs. But the conflict had expanded beyond a single porch and a single afternoon. It now involved a statute, an insurance policy, 2 attorneys, and a scheduled court date. There was no public spectacle, no dramatic confrontation, just a widening circle of accountability that required paperwork, signatures, and patience. 3 weeks after the criminal summons was issued, the first district court appearance took place on a Tuesday morning. I did not testify that day. It was a procedural setting. Lauren stood beside her attorney while the charge of simple assault resulting in injury was formally read into the record. A new court date was scheduled. The case was continued to allow for exchange of evidence. Nothing dramatic happened in that courtroom, but it fixed the matter in public record. 2 days later in the civil track, Lauren's attorney noticed my deposition. Thomas explained what that meant in practical terms. I would answer questions under oath in a conference room with a court reporter present, and the transcript could be used later in litigation if the case did not settle. The deposition was scheduled for the following Thursday at a law office in downtown Raleigh. I arrived with a folder containing the same documents that had followed me since the first week ER summary. MRI findings, physical therapy schedule, the 911 call log, and confirmation of my short-term disability approval. Thomas had already exchanged copies through formal discovery. Lauren was not in the room. Her attorney conducted the questioning. He began with basic background employment history, prior injuries, any history of back pain. He asked whether I had ever sought treatment for spinal issues before May 17th. I answered no. He then shifted to the afternoon of the fall. He asked whether Lauren and I had argued earlier that day. I said no. He asked whether I had consumed alcohol. I said no. When he reached the ring footage, he asked whether I agreed that the video had no audio. I confirmed that it did not. He suggested that the movement of Lauren's hands could be interpreted as an attempt to steady me rather than push me. Thomas objected to the form of the question but allowed me to answer. I said the video showed forward force before my body moved backward and that there had been no loss of balance prior to contact. The attorney then produced a printed still frame from the original social media clip Lauren had posted. It showed me mid-fall, blurred, without the moment of contact visible. He asked whether I agreed that from that angle it appeared I had simply slipped. I said that angle did not show what happened seconds earlier. After 4 hours, the deposition ended. The court reporter confirmed the transcript would be available within 10 business days. That evening, Thomas called me with a development. Through formal discovery, Lauren's legal team had produced the original file of the clip she posted online. The metadata indicated that the recording on her phone began approximately 20 seconds after the timestamp visible on Daniel's ring footage. There was no recording from her device of the actual contact. The absence was not proof of deletion, but it established that her public clip did not capture the entire sequence. Thomas explained that the timeline alignment between the ring video at 4:11 p.m., the 911 call at 4:12 p.m., and the start of Lauren's recording at approximately 4:12:30 p.m. created a structured chronology. It showed what was recorded and what was not. The following week, the insurance adjuster requested mediation before trial. No settlement offer was made yet. The request itself signaled movement. The pressure no longer came from social media comments or family calls. It came from sworn statements, time-stamped files, and coordinated calendars between court and counsel. I did not feel victorious, but I felt oriented. For the first time, the conversation was no longer about whether something had happened. It was about how it would be classified and at what cost. The criminal court date fell on a humid Monday morning in late June. By then, I had completed 6 weeks of physical therapy. I could move without the brace for short periods, but I still avoided lifting anything heavier than a grocery bag. The fracture was healing, but not forgotten. In district court, Lauren stood beside her attorney again. This time, the prosecutor had reviewed the ring footage, the 911 log, the medical records, and the deposition transcript excerpts that had been shared through formal channels. Before the case was called, the prosecutor approached Thomas and me in the hallway. She explained that after discussions with defense counsel, the state would offer a plea to simple assault resulting in injury. The offer included 12 months of supervised probation completion of an anger management program approved by the court and payment of court costs. There would be no jail time unless probation was violated. The prosecutor made it clear that the state believed the evidence supported the charge, but that misdemeanor cases often resolved through plea agreements to avoid extended trial calendars. When the case was called, Lauren entered a plea consistent with the agreement. Before the judge began the formal questions, she turned slightly in my direction. It wasn't dramatic, no raised voice, no visible anger, just a brief glance. Her attorney leaned toward her and whispered something I couldn't hear. Then she faced forward again. The prosecutor summarized the evidence for the record: the ring footage, the 911 timestamp, the medical diagnosis confirming a lumbar compression fracture. The judge asked whether she understood that by entering the plea she was admitting responsibility for the act described in the charge. There was a pause. "Yes, Your Honor." The words were procedural, but they were recorded. For weeks, the public version had been that I slipped. In that courtroom, under oath, she acknowledged responsibility for the shove that caused injury. The judge accepted the plea. At that moment, the narrative shifted permanently, not online, not privately, on the record. The judge asked a series of standard questions to confirm that the plea was entered knowingly and voluntarily. Lauren answered each one. The judge accepted the plea, entered a conviction for misdemeanor assault, imposed probation under the outlined conditions, and scheduled a compliance review date. It was procedural, controlled, recorded. There was no apology directed at me. There was no acknowledgement beyond the legal language. I understood then that any future relationship between us would have to exist outside denial. But the court record now reflected a conviction. That afternoon, Thomas received a call from the insurance adjuster. With the criminal matter resolved through a conviction, the adjuster indicated the carrier was prepared to make a settlement offer in the civil claim. The offer covered my documented medical expenses to date, projected physical therapy through the end of my treatment plan, and verified lost wages during my medical leave. It did not include additional damages for pain and suffering at the level Thomas had initially demanded. Thomas and I reviewed the numbers line by line. He explained that while a civil trial could potentially result in a higher award, it would also extend the process by months, possibly more than a year, with no guarantee of outcome. The criminal conviction strengthened the liability position, but juries remained unpredictable. I asked for a day to consider. That evening, Lauren sent no messages. My parents did not call. The silence felt different from earlier weeks, not tense, contained. The next morning, I authorized Thomas to counter slightly above the insurer's offer, but within a range he described as realistic for settlement. By the end of the week, the parties reached an agreement. The settlement required a signed release limited to claims arising from the May 17th incident. The insurer would issue payment within 30 days of receiving the executed documents. There was no public announcement, no press, no statement from Lauren's business account, but the consequences were now documented in 2 systems. In criminal court, a misdemeanor conviction and probation terms. In civil records, a negotiated financial settlement tied to a homeowner's policy claim. Lauren's authority in the narrative had narrowed to compliance with court conditions and insurance paperwork. I returned to physical therapy that Friday with a copy of the court disposition folded inside my folder of medical forms. The therapist asked how court had gone. I said it was resolved for now. The conflict was not erased. The fracture had not vanished. The relationship between us had not healed. But the shove had been classified and the cost had been assigned. The outcome was not dramatic. It was official. By early autumn, the brace was no longer part of my daily routine. My orthopedic follow-up confirmed that the lumbar fracture had healed as expected. I was cleared to resume normal activity gradually with a recommendation to continue core strengthening exercises at home. Physical therapy formally discharged me the following week. The settlement check from the insurance carrier arrived within the 30-day window outlined in the release agreement. After attorney fees and medical liens were paid, the remaining amount covered my out-of-pocket expenses and the income gap from the first unpaid week of leave. I placed the documentation in a folder labeled May 17th and stored it with my tax records. In criminal court, Lauren's probation terms began immediately after the plea. According to the publicly accessible docket, she enrolled in a court-approved anger management program within the required time frame. A compliance review date was set for the following spring. There were no violations noted in the first status update. We have not spoken directly since the plea hearing. My parents attempted to arrange a family dinner in July. I declined. I explained that until probation was complete and consistent boundaries were respected, I would not participate in shared gatherings. I did not frame it as punishment. I framed it as structure. Lauren's business website was updated quietly in August. The homepage removed the video content section where the original clip had once circulated. There was no reference to the case. The original social media post was eventually deleted. Nothing about the outcome felt cinematic. The court record remains searchable. The insurance claim number exists in an archived file. The MRI images are still stored in the hospital system under my name. The ring footage sits in a digital folder on my computer, unchanged from the day Daniel sent it. What changed was not the past. It was the classification. The shove is no longer described as a misunderstanding or a slip. It is recorded as a misdemeanor assault resolved through conviction and probation. The medical bills are not framed as overreaction. They are listed as compensable damages in a closed claim. I returned to full-time work in September. My supervisor documented the end of medical leave in my personnel file. No further HR actions were required. On a practical level, my life resumed its ordinary shape: commutes, deadlines, groceries, laundry. But the boundaries are different now. I do not attend events at Lauren's house. I do not engage in private negotiations about what really happened. If questions arise, I refer to the public record. There is a steadiness in that, not triumph, not revenge, just alignment between what occurred and how it is officially described. If you have ever watched your own experience be reframed into something smaller or more convenient, you know how destabilizing that can be. What I learned is that documentation does not erase harm, it anchors it, and sometimes that is enough.
This story is creative content developed for storytelling and reflection. It does not depict any specific real individuals or